Hello and good evening, I'm Right Blend. Welcome to my summary of day 2 of the trial of Pat King. There was no video yesterday because the trial was adjourned. The defense counsel, Natasha Calvino, was not feeling well yesterday, so that's why there was no video yesterday. We have so far heard from 3 witnesses in full, and we have started or mostly completed the Crown examination in chief of the 4th witness. All 4 witnesses so far in the trial are recycled or the same witnesses that also appeared in the trial of Tamara Lich and Chris Barber, which is ongoing, though in that trial I don't believe the defense is calling any evidence, so things will now go to the arguments upon any outstanding issues so forward. I'm really not too clear on how things are going to proceed at this point, but as soon as I know, you'll know. So follow along. If you're new to the channel, subscribe, like the video, comment. It really helps me a lot, and it really helps make what I'm doing, helps me know that someone appreciates it, and it means a lot when you write a comment or you participate in the conversation, which is great, phenomenal. It's difficult to sit in the courts and to listen to some of the things that they're saying about a protest that I participated in, that I know why I was there for good, just reasons. And I believe that our country was in a very perilous position when the Freedom Convoy came to Ottawa and protested the ongoing mandates that were ongoing and ever-changing. And I do believe that they would have lasted longer, they would have been elongated, and there would have been more fluctuation on ending them. And we can see during the Freedom Convoy the provinces reconsidering their positions and ending their mandates. Certainly Alberta and Saskatchewan right away. Quebec, we're going to have a tax on people who refused the poke, and they ended up canceling that, I believe, the first day of February. But diving right back into what happened today, again, if you want the fine details and you want to go through it with a fine-tooth comb, go ahead, follow me on Twitter, Right Blend, and get into my thread from today, and you'll find all the details and back and forth as you want. It's basically a fairly inaccurate transcript of what happened in court. I summarize, I abbreviate, I simplify, and I make a little bit of mistakes here and there, and I appreciate you bearing with me on those. Today we heard from Vivian Lear, who is the administrator of a church on the corner of Kent and Wellington, St. Andrews. And we also heard from another witness from an earlier trial, the trial of Lich and Barber. We heard from Chantal Bureau, who manages and owns a high-end fashion boutique in the Byward Market region. So with the first witness, Vivian Lear, there was testimony about the horns, the sounds, the smells, a lot of different things. Some of the stuff that stood out during Miss Lear's testimony, Miss Vivian Lear, was her testimony about feces on the property, though she never directly observed who was making them. It could have been anybody. That's a very busy area of downtown Ottawa that has, as she admitted on cross-examination, a lot of unhoused people coming through there at the corner of Kent and Wellington, and there's always a lot of garbage. She was very pointed to make a note of, she was very certain to make a note of the amount of garbage that accumulated during the Freedom Convoy. She testified that it was more than normal, but certainly she admitted that they have garbage bins on the corner there, and they do get full during normal times from all kinds of different people. She also admitted in cross that she never got the identity of any of the people she confronted, no license plates, nothing like that. And we're going to talk again, of course, about the Led Zeppelin truck. There was a truck parked, I believe, on the north side of Kent, very towards the very end of the street near Wellington, that was playing loud Led Zeppelin music that she said would start very early, would be very loud. She said at one point she had enough. She confronted him, and that turned a little bit nasty. She said that the driver of the truck playing the Led Zeppelin music, here forward the Led Zeppelin truck in her conversation, swore at her and was very angry. So she did not have a positive experience with that at all. Let me just put this down here. And that was, but she also noted that the police had walked up to the confrontation at that point, and she noted that it was, that they talked to the Led Zeppelin truck, and that he did, there was a change. He lowered the music. Not enough to her liking, I don't believe, according to her testimony, but he did lower the music down, and the police were, I guess, satisfied at that point. She made no calls to 911, nor the non-emergency line of the Ottawa Police Service, nor did she call Byward or the city for towing or bylaw infractions. I don't know if she testified if she saw ticketing or not. Actually, I think she testified she didn't, but she was asked on cross, and I'm jumping around a little bit here because this is where my line of thought is, so follow along. not chronologically in order to how things transpired, but again, she testified about a lack of ticketing and enforcement, and then she was asked by Natasha Calvino for Mr. Patrick King about how things would happen on a normal day, and she admitted that after some reluctance, I'll be honest, that there were instances where people would park outside for mere minutes, and then they would be ticketed, and including the director of music for the church and other people. And the defense really picked at this and said, it made you mad, more or less, that these people who are doing good things, bringing donations to the church, visiting, what have you, are ticketed for parking illegally along that area there, not in a designated parking spot, whereas there was no enforcement during the Freedom Convoy. And I think she admitted that that was fair. Again, go through the thread if you want the exact back and forth. So another point of Vivian Lear's testimony that was interesting was her testimony about the level of sound coming through to her office area. And it's interesting because the church has really thick walls. As she testified, it was built in the 1800s, and then there was some additions, and then there's a modern addition more recently. The sanctuary, I think at one point she testified, was granite walls, but actually I think later amended that to be limestone, but nonetheless thick stone walls. And that the noise was unbearable and constant, but also at another point admitted that the horns were sporadic. And we'll talk about Crown re-examination, because I think that's what hurt them the most. The Crown hurt themselves on the re-examination of Vivian Lear, in my opinion, and I'll tell you why. But so she's testifying about the horns and the thick stone walls of this church, and she says that her office is actually the more modern section. I don't know if it's in a tower or what have you, but it's set back, according to her, and she spends 90% maybe of the day in her office when she's there, and then I guess the other half of the day she works from home in the afternoons, 5 days a week. At Convoy, she was working 4 days a week during the weekdays. One day, I believe it was Tuesday, was entirely remote with the same schedule. However, so she was hearing the horns in her office. She said she could still hear them in the sanctuary and where the congregation would gather, but not as intensely as in her office because of the thick walls, but that the smells permeated and penetrated the entire building. Gasoline, diesel fumes, the common theme that we're hearing from all the witnesses about these terrible fumes that are so bad that Pat King should go to jail for 5, 10, who knows how many years. And as I commented on today, I don't think it's appropriate. There was a lot of focus on feelings. I don't think it's appropriate to have the opening of this very serious criminal trial be, in my opinion, what is mostly feelings of people. And when you're looking at putting someone away for this significant amount of time, and you're talking about feelings and over facts, really, that's not appropriate for the opening of the criminal trial. Now, the Crown said the majority of their case is Patrick King's own social media, so I guess we'll cross that bridge when we get to it. But so far, we're opening with feelings, and a lot of the statements being made cross the line, in my opinion, into what constitutes a victim impact statement. And that, as we heard arguments of during the Litch and Barber trial, those kind of impact statements are more appropriate if and when there is a conviction at the end of the trial, not in evidence of trial, you know. So it's really just a different bag of things of how to handle this. And I'd say the judge is fairly fair. One thing that happened, there was some different objections. Miss Calvino's definitely getting on her feet and doing a good job for Mr. King. One objection, interesting, was the Crown started to ask in their examination Miss Lear about comments she received after Convoy, after her testimony in the Litch and Barber trial. How, you know, she testified that people had found her work email and were harassing her and harassing the minister of the church, the worst thing she's ever received in her life. And the Crown and the defense objected to this, basically saying, what's the relevance? What's the relevance of her interactions and feelings and messages after the testimony she gave at the Litch and Barber trial? And I believe the judge thoroughly misunderstood this. So there was an objection, the judge maintained it and allowed things to go forward. And during the objection, the defense asked what was the relevance of this line of questioning, asking Miss Vivian Lear why she was describing how the reaction she got to her testimony during the Litch and Barber trial made her feel. And the Crown said it goes to proving that the witness is lack of motivation to fabricate things. And then the defense was like, I'm not accusing the witness of fabricating anything, nor would I ever accuse the witness of fabricating anything. That's not happening here. So, you know, and it's ridiculous. It's a little bit silly. It's a lot of it silly. And the judge was basically like, well, it's important, so let's hear it. And so we go back, and Miss Lear continues her evidence and starts talking about those emails and stuff. And the judge clues in and says, well, as I understand, I mean, I think I could be wrong, but this is how I observed that, and I believe I'm right. And the judge said, well, hold on, I thought you were talking about your experiences during convoy, not, you know, messages received afterwards. I don't think that this is relevant. It goes outside the realm, I believe is the word he used. And we moved on. So the defense was correct, and they're objecting to that. And I wanted to bring that point up. There was other objections along the way, a lot of hearsay objections by Miss Calvino at different points, different people, different witnesses talking about things, somebody told them, whatever, it's hearsay. There was other objections. I think the Crown objected a couple times. There may have been objections on other grounds. Like I said, the objection of relevance we just heard about in that example. But overall, a very fierce back and forth in the sense, in a courteous type of court environment and rivalry between adversarial lawyers. It was still respectful, of course. But again, does this justify the extreme length of penitentiary time they're looking at for Mr. King? I don't think it does. We heard from Vivian Lear, talked about the Led Zeppelin truck, talked about confronting the Led Zeppelin truck, talked about Led Zeppelin truck swearing at her. Again, not Pat King, not directed by Pat King. To my observation, none of anything we heard today had anything to do with Pat King. None of these people knew Pat King. None of these people interacted with Pat King. None of these people follow Pat King on social media, according to them. So I don't know how this is relevant to his trial. I know the Crown's taken the position, the absurd position, that the entire convoy was a mischief from day one, which is just totally unconstitutional and not a proper legal position at all. Because, of course, certainly on the first day, they had a right to protest. So it's just ridiculous. It's ridiculous what's being done of our Constitution, our Charter, our Section 1 reasonable limits, how that's being abused by the powers that be. And when he heard from Mr. Peckford, Brian Peckford, the Honourable former, I believe, Premier of Newfoundland, I believe it was Newfoundland, could have been Nova Scotia. I'm going to put my money on Newfoundland. Nonetheless, he's the last living person who signed our Charter of Rights and Freedoms, the Constitution Act 1982, I believe. And according to him, the reasonable limits of Section 1 in the Charter are for absolutely dire national emergencies of unbelievable proportions, not just for the whim of a random police officer or a Crown attorney or someone to go, well, you exceeded reasonable limits. So anyways, I think apparently that was a philosophy of the clause when it was included and signed. So I'll take his opinion as someone who was party to those proceedings over anybody else's, and that's just what I'm going to stick to that. I know there's different legal tests and different legal theories. I don't hold them in the same weight as somebody who was actually there and who negotiated on those terms. So moving forward, again, back to Vivian Lear, testifying about the sounds, testifying about the noise, could hear the sounds, big thick walls in this older church, could not really hear it in the sanctuary, could hear it better in her office, which is set back and more modern. So how did she get to work every day? She testified she took transit. She walked a short distance and went back and forth every day that she needed to be. Of course, not the days that she was remote or the afternoons where she was remote, but she got there and back, no problem. And she testified that they missed one Mass. I believe it was the January 30th Mass, the Sunday, January 30th. And the defense kind of went into this a little bit more and asked her about the restrictions at the time in Ontario, when churches could reopen, how they were reopening. And Vivian Lear admitted that her church was having a lower congregation numbers during COVID, and also that the number of church attendance in general, she said, is on the decline. And they were excited to reopen it in person, but they were doing so gradually according to guidelines and to facilitate the comfort of their congregation, especially older people, etc., when it came to these things. So she was very observant of the protocols, and as was the church. They had a 50% reduction at some point. I believe it was the 31st. It went up to 50%. Below that may have been lower. So she said they actually went into the sanctuary. They counted the chairs. They reduced the seating as needed, and that's how they complied with the measures. So the defense made the point that it's possible that some of these lower attendances that she said in the Crown Chief examination, where it's 1/3 to 1/4 reduced, may have been in her suggestion, I believe, in her evidence in the cross, that it may have been due to these restrictions and less people. But Vivian Lear also testified that there was a noticeable bump after the convoy ended, but it wasn't a huge one, but it was noticeable. So that contradicts that, I believe. But there's certainly, the truth is somewhere in the middle. The restrictions were limiting their attendance. People were scared of the disease, and then the added anxiety of whatever fears, founded or not, they had about the protest. She testified that other than the first January 30th, the minister was able to get to and from the church every day. So that's good. Every time they needed that. The police even offered to escort the minister if they needed it, if they felt they needed it for safety reasons, but they never took them up on that offer. There was some complaints, I believe, from Ms. Lear about the police presence. She said she never called 911 because they were busy keeping the peace or something, but she never called. And they never took them up on the offer to escort the minister. The minister got there for the other Sunday services. They had the congregation come, maybe not as many people, but again, there's the question of what effect did the restrictions have versus what effect did the protest have. Ms. Lear testified she never tried to drive in. She just took transit, so we don't know. When it came to that, she said she took the clothing and stuff off their Jesus statue that she found. She didn't see who put them there. She did say she caught people peeing a couple times and confronted them, and then they went away, so she never called the police about those. But when she confronted Led Zeppelin truck, there was swearing and police were nearby, walked in, and I guess de-escalated and ultimately had him lower his music, though not to a level that she found acceptable. So it's that. She was complaining about music, horns, megaphones, and, you know, it was difficult because she never identified any of the people who she had a problem with. So she never saw them before or since. She never identified any of the license plates. She never called the police on anyone. She never took the police up on their offer to escort the minister. The minister got there anyways. She testified to their lack of income and loss of income. I think she placed the dollar value of it, impact financially, at around $3,000. Lack of rental of the space, lack of AA meetings, lack of government rentals coming in. That could have been due to restrictions, could have been due to the protest. I do believe she blames it on the protest. So that's where we are with that witness. And as well, she testified that she is a party of the class action, the civil suit against the convoy. Not personally, but the church, and she enrolled the church in that. And I believe she said that she had seen the class action online and then reached out to Paul Champ to become involved in the class action against the convoy, which is hundreds of millions of dollars that they're trying to get in compensation. So that's the meat and potatoes of Vivian Lear. We heard a lot about her as well from the trial of Tamara Lich and Chris Barber. The next witness, so that was all done today, introduced and done today, chief examination and cross examination. So both parties finished with that. Then on re-examination, they asked her to define, because she was talking about horns timing, said in the morning when she would get there, she wouldn't be there all the time, not there on the weekends, not there the first weekend, didn't make direct observations because she wasn't there. You know, when she's talking about reduced congregation size, she's doing this from a virtual observation, from watching YouTube or Zoom numbers or something like that, not there physically. So that's another point the defense was able to bring up. Another thing is she testified, I believe, about on re-examination, the Crown, when they asked the question after defense did their cross, about her, particularly when it came to the sporadic definition she used for horns, and she defined it as 3 or 4 times per hour in variable lengths. So I noted the judge was very attentive to this point. So I don't know if that hurt or if that helped or hurt the prosecution. It may have hurt them, especially because she said that it became less after the injunction and so forward. Then we go to Chantel Bureau. She owns the high-end fashion store in the Byward Market. We heard again from her during the trial of Tamara and Chris. She talked about the impacts the protest had on her business, less foot traffic. She did admit that she locked the door and controlled who was coming in and out. during the protest, and on a regular day, in a good year, she'd have, in January, she'd have 10 to 30 people a day coming in. She put her monetary loss at $45,000 in cross-examination for the duration of the protest, though in cross she admitted that she's comparing that number to January and February in pre-pandemic times, so not to 2020, not to 2021, not to 2022, but 2022 compared to 2019. And she was asked if she was ever asked to produce receipts about those number claims by the police or anybody else, and she never did. She still maintained an online business during the entirety of the protest, was able to get her shipments from the store when someone would make an online order, that she would be there every day to tend to the online side of the business, whether or not the store was closed due to restrictions or otherwise, and would take that to the post office near her house. She was able to drive to work every day, to park in her designated parking space every day. The National Capital Commission, the NCC, is her landlord, and she was able to continue her use of the parking lot, walk to and from work. She testified she was not terrified, I guess is the word she used, or afraid or frightened, but she was very unhappy with it. She didn't feel like concerned for her safety, but she described at least one instance where she asked somebody to move from the doorway who was smoking, and there was someone who called her some derogatory words. She didn't enlighten us on what they were, but the defense counsel was sympathetic to that, so that's not appropriate. But again, same thing. No, she never identified any of the plates of any of the vehicles parked on Sussex, never identified any of the protesters, never met Pat King, never interacted with him before or after, so on and so forth. And this is interesting, this is important. She said the horns, though, her testimony was different than Miss Lear's. She said the horns were absolutely constant, didn't notice a difference after the injunction, it never stopped. She testified she's near the crux of the trucks, near the famous Rideau and Sussex corner, about a couple blocks up the road from that on Sussex. She testified specifically about the delay of one particular shipment, where she said that she got it 3 weeks later on this, and as being a high-end boutique, she typically has one quantity, low ones of each item, maybe 1, 2, 3 in each size. So if somebody buys one, it's gone. And she had this particular delivery of this particular line of brand that she's well known for carrying, or she's a rather exclusive provider of. And the person, once she ordered this, it was delayed, and even she said people can only be so loyal. When they want the product, they'll go somewhere else. So she said that was a major loss of business for her, having that product delayed some time. And the defense at one point asked her if this could have been delivered earlier, if this was ordered earlier, and I don't really remember where that line of question terminated, whether we determined if that was ordered earlier on or later on, and exactly how that came to be delayed, if it was ordered early January and was delayed through before convoy or after convoy, I don't remember exactly, but this was a major point of contention for her, that she had missed out on this this exclusive line of product that she was to receive and to sell, either online or in person, but it was delayed and it cost her, and she ended up having to put it on sale when she finally did get it, and she never had to do that because the majority of this thing would sell on the first day, so that was a big business loss, according to her. She also testified that her business is part of the class action lawsuit, as with Vivian Lear and the church, but not personally. She's not personally part of the class action. She is, her business is, so she's the owner and proprietor of the business. So that means all three witnesses so far are part of the class action. I know there was a Miss Delaronde from the first day, kind of danced around that a little bit, but she hasn't withdrawn, so she is technically part of it. She's also a personal friend, her words, of Paul Champ, so we'll see how that goes. I mean, I don't know how it's going to develop into anything more curious. We finished with the witness, so not really. We'll see how that goes, but we'll see how the civil suit progresses. And certainly I'll try to cover that as the time comes. Miss Bureau testified, again, coming to work, driving to work. She says she had 2 part-time employees. One of them lived on Rideau and moved out of the area during convoy because the noise was so unacceptable. I guess she moved out of town, so she lost that employee. And she said she had to lay off another employee who lived farther away. because there was a lack of business. But again, there was a back and forth between the defense and Miss Bureau, sorry if I'm saying that wrong, about the circumstances surrounding this lack of business and lack of traffic. Again, during convoy, she had no interest in allowing protesters into her store. So whether somebody would come and do business, they were never given the opportunity. She had no interest in having them in the store at all. So she completely locked the door. She didn't want them in there. And that's an important takeaway too. Like, she made the choice not to have those people participate in their business, even if they wanted to. She did not want any of them in her doorway. She cleared them out, mostly without incident, according to her, except of course for that notable incident where she was called a derogatory name, and things proceeded that way. So she didn't want those people in there. She controlled access to the store unit, and that's how she ran the business. She said she suffered a $45,000 loss that she did not provide receipts for, according to what I remember of the testimony today. Again, go back to it. Go back to my thread for the most accurate interpretation. As always, consult different sources to get the most accurate picture of things possible. So I think that's most of her testimony. She's a business owner of a high-end fashion boutique store for women. Used to be with men too, used to offer that, but that was a while ago. She's been in the business. I remember the defense said, "You've been in business for upwards of 30 years. And I think she said, no, 27, which is potato patata. You're right there. You're close enough. So I don't get it. That seems just like a little bit petty to me even. Again, she was not willing to have any interactions with the protesters at all. I don't remember if it was her or Miss Lear that the judge asked if you had any positive interactions ever with the convoy, and they said no. I believe it might have been Miss Lear. The judge basically at one point interrupted to say, did you have any positive interactions at all with the protesters throughout the entire convoy? And they said no. I do believe that was Miss Vivian Lear, but an interesting point. So that's how things are progressing. We heard from Chantal Bureau. She talked about constant horns, smells permeating her unit, but I think she said she couldn't really smell the smells, but she could hear the horns loud and clear. So the smells were outside, the smoking, and she said that it was rather obvious. I believe it was her, it might have been Miss Lear, who said it was rather obvious to identify the protesters, but again, neither of them identified anyone individually, never seen any of the people who caused them chaos again or after. Or before, so no identification of any of these people, no knowing who they're associated with, but we do know for certain that they were not Pat King. So, and again, membership or participation in some way in the class action lawsuit, so you could argue there is a monetary incentive for a conviction, which could strengthen the civil case. That's important to bear in mind. It is a potential conflict of interest. But again, the Crown, for some reason, feels these are the best witnesses to bring forward. I don't know if there is any witnesses they could bring forward who may not be a part of that class action, who'd be willing to testify in this nature from that geographical area. So who knows? But certainly, just it's a situation and a half. And I feel like there are some genuine concerns for our freedoms here in Canada from these proceedings. And the way they go down will determine how this country proceeds. So very important to follow this along. You're following a historic event here. Whether you support Pat King or not, everyone deserves the presumption of innocence and the right to a fair and impartial trial. And I think that's happening so far. The witness choice is confounding and confusing, but this is where we are. With Chantal Bureau, I don't think I missed anything important. I mentioned her situation, her business, her lawsuit participation, her complaints of the noise and the smells, as all the witnesses do. However, her description of the horns is constant before and after the injunction. And I think she also interestingly testified about how something along the horns is just when you think you're at your wit's ends, the horns would begin doing a musical note around, I think every day. She testified at 4 o'clock exactly, the trucks would begin doing musical horns, and that would just be completely aggravating for her. So that's a testimony we heard today. We concluded with her. I don't know if the Crown had any chief for her, I don't think. And then we began with Natalie Hanaud, who is of OC Transpo, formerly a special events and business and special events coordinator, someone who plans detours for protests and Canada Day and stuff like that for the municipal bus service in Ottawa, OC Transpo. And she testified at length about how bus stops work, what are temporary bus stops, what are bus detours, where the number 6 bus goes, what left and right turns it makes, you know, how the wheels on the bus go round and round. And I appreciate that she's being very direct and technical, but it's rather boring in comparison. We're not done with her testimony yet. I think she'll finish tomorrow morning. The Crown's we adjourned, and the Crown still had a few questions for her. Possibly, we're open that the Crown could continue with a couple more questions for her, but they asked, how many routes of OC Transport were affected. She testified 18. What services, what kind of detours did they have to make? How much mileage or kilometers did that add to the routes? How much delays? She couldn't speak to a lot of it. She was also a participant at the RCC, the National Capital Region Command Center, which is where the RCMP, the Ottawa Police, the Ottawa Traffic Unit, the Ottawa OC Transpo, Ottawa Carleton Transpo, everybody comes together and meets. So it's very important. Only high-level people get in there. Where she testified, she saw cameras about things happening on streets, the setting up of Jersey barriers and the removal of Jersey barriers after the trucks left. She said there was a delay in restarting OC Transpo service after convoy ended, I think until February 23rd or 24th, because they had to have the plowing done. They had to have roads come in, Ottawa, a division of the City of Ottawa, come in and remove the heavy Jersey barriers. So she testified to those. And I believe the defense asked both Vivian Lear and Chantel Biro about the Jersey barriers, to which they replied that the Jersey barriers were... they didn't remember them being in front of trucks or behind trucks, or maybe at some intersections and not others, or they didn't remember police vehicles blocking some intersections or not others. Well, this reminds me of an interesting point. I believe it was during Miss Vivian Lear's testimony where the Crown presented the defense presented a picture that was in disclosure that was dated February 4th, and the defense and the Crown objected to the date of February 4th on this aerial drone footage or photo before the morning break, and they said basically they didn't agree about the date. And then we came back from the morning break, and suddenly the Crown and the defense were in agreement about the date. So that was very silly, and the defense said that if this is going to be the way things are, we're going to have a lot of delays in this trial. And the Crown's like, well, we're not trying to be obstructionist, but at the same time, it's their disclosure. This is something that was verified in the trial of Tamara Lich and Chris Barber. It was the same picture, one of the same pictures in the exhibits of Chris and Tamara's trial. And the Crown made the argument, well, this isn't the trial of Tamara and Chris, this is another trial. It was very silly. And after all that, they come back from the break and suddenly, okay, let's file it with the date. The judge had sided with the Crown. It was basically like, okay, we'll wait till the police come and testify, and they'll probably know something about this picture and can tell us what date it was taken at. But then they come back from the morning break, and the Crown's like, well, we now are in agreement with the defense. We'll file that as February 4th, like it says. It's our picture. It's our disclosure. It's from the police service. It's verified in another trial. And they made a big stink about it. So I don't know. I mean, it's just... unnecessary. I don't know what the point of that was. Was there a point? Probably, but maybe not a good one. Was it just to... I don't know. Was it the equivalent of a toddler throwing their toys on the ground because they're not getting their way? I'm not sure. But the judge sided with them in that, and then we come back from the break, and all of a sudden everything's okay, and yeah, we agree that's the date. And back to Miss Hano. Natalie Hano from OC Transpo. She works at a different department now. At the time, she worked as the detour planner for special events and so on. She testified about 150 stops being impacted through 18 routes, the 6, the 7, the 10 maybe, the 14, some other ones. She named a lot of them, and special routes like 600, at least one 600 route with which does school routes, and then Paratranspo not being able to get down every street because in normal circumstances, if there's snow buildup, we do live in the City of Ottawa is the terms she used, I believe, and also streets having double parked cars or whatever. So it's a normal issue they run into, and normally they say if there's an issue, the Paratranspo operator who doesn't run on a fixed route, they go door to door. So they pick you up at your house, bring you to the grocery store, and bring you back, but you have to have a medical application into Paratranspo to use that service. It's also delivered through the taxis in the city that partner with OC Transpo to deliver Paratranspo taxi service, as well as the minibuses run directly by Paratranspo, a division of OC Transpo in the City of Ottawa. So that service was impacted because of snow buildup, I guess, and double parked cars. I don't know. She didn't say directly, but she said that in normal circumstances, those are some of the issues Para runs into. And if that is the case, the operator for the Paratranspo bus calls normally to their control center, and then if it's an illegal parking bylaw comes, or if it's a snow problem, roads comes, or whatever. And that's basically it. So that was pretty long and technical, and I believe we're going to have more. I think the defense with that might try to go into, how can you say for sure what Pat's involvement was, or was the impact that great? Because there was a lot of things that the Crown was trying to get to. what were the minutes delayed added by these detours? You know, what was how much did this deviate from OC Transpo standards, which is, I believe, 500 meters per stop distance on a route in the urban center? And I think Ms. Hano testified it went up to 1 kilometer, which is closer to the suburban standard of 900 meters at some points. She talked about the weak points, which is the 3 canal crossings OC Transpo uses: Rideau Street, Mackenzie King Bridge, and the what street is that there off Main, that little bridge, Pretoria. And if they have an event where one is closed, they ask that the event not close the other 2, and that when they start to lose 2 or more, things really back up. It's like a rippling effect of traffic throughout the entire area. And they said that for the duration of convoy, they ended up having to reroute the buses to do ramp surfing, to use the 417, I guess, to traverse the canal, probably from Nicholas to Metcalfe, though we didn't get to the technicality of that. Anyways, I think that's a pretty good overview of what happened today. I hope you found my commentary insightful. I hope you enjoyed this video version. I know it's really, really long. So again, it's really, really important that you like this video, that you share it, that you write a comment, and that you subscribe so that the algorithm knows that you're interested in this. And I would make 2 videos a day, but folks, I'm sorry, that's just too much for me. I'm going to go home, enjoy my evening. Tomorrow, Thursday, I'll only be covering half of the day, unfortunately, and I'll be back on Friday for the full day. I'll try to pump out a video on Thursday as well. Though I will miss the afternoon half of things. Till next time, peace out.